This next session covers acquisition and relocation. There we go. So we'll have a brief introduction, then go over the types of acquisition, the acquisition process, types of relocations, and the relocation process. A few applicable regulations that we have to follow. The URA regulations effective June 3rd of 2024, implementing the Uniform Relocation Assistance and Real Property Acquisition Policies Act. Section 104 of the HCDA. 24 CFR 570.606 of the CDBG regulations, and Section 414 of the Stafford Act. Let's go over a couple definitions before we jump into processes. A permanently displaced person is an individual, family, partnership, association, corporation, or organization which moves from their home, business, or farm, or moves their personal property as a direct result of acquisition, demolition, or rehabilitation for a federally funded project. This would not include persons displaced temporarily from their dwelling for less than 12 months while it's being rehabilitated, the person with a court-ordered eviction for cause based upon serious or repeated violations, a person who occupied the property for the purpose of obtaining relocation benefits, someone who the subrecipient decides in the state and HUD agrees in writing that they were not displaced as a direct result of the project, an owner-occupant of property who moves as a result of voluntary acquisition, rehabilitation, or demolition. Please note that the tenant of a structure like that would be eligible for relocation benefits, or a person who, after receiving their notice of eligibility, is notified in writing that they will not be displaced. Next, we have a program or project. This is any activity or series of activities undertaken by a federal agency or with federal financial assistance received or anticipated in any phase of an undertaking in accordance with the federal funding agency guidelines. The purpose of the URA is to ensure owners of real property to be acquired are treated fairly and consistently, ensure displaced persons are treated fairly, consistently, and equitably, ensure agencies implement regulations in a manner that is efficient and cost-effective, ensure owners and displaced persons are informed of their rights, and ensure that all reasonable steps are taken to minimize displacement in implementing activities. The URA applies to displacement that results from acquisition, demolition, or rehabilitation for HUD-assisted projects carried out by public agencies, nonprofit organizations, private developers, or others. It also applies to real property acquisition for all HUD-assisted projects. The source of funds used to pay for an acquisition does not matter. The URA does apply anytime CDBG funds are used in a project, regardless of purpose or activity. No project-related acquisition may occur after the date of the pre-application public hearing until the environmental review process is complete and our offices issue the authority to use grant funds or AUGF. Acquisition is a choice-limiting action that can result in repayment if conducted between the application public hearing and AUGF issuance. The following acquisitions are not subject to Subpart B. Acquisitions conducted prior to the date of the pre-application public hearing, temporary easements or permits needed solely to perform work intended exclusively for the property owner's benefit, non-specific site acquisitions, and voluntary acquisition provided that a few requirements are met. First, the subrecipient must state in an acquisition notice that they either do not have or will not use eminent domain authority, and the acquisition notice must state the property's fair market value and the basis of valuation, and the market value must be determined by appraisal or written opinion. We'll dive deeper into these items later. Property owner has 3 rights under the URA. They're entitled to just compensation for their property, the right to an appraisal and review appraisal, and the right to accompany the appraiser during the appraisal site visit of the property. The subrecipient must inform the property owner in writing of those 3 rights. Next, we'll hop into the types of acquisition. Full title refers to just your basic purchase of a parcel of land. As far as long-term leases go, leases of 50 years or more are considered acquisitions and subject to the URA. A right-of-way is a type of easement that allows anyone to pass through a portion of land, so it's public land. Then we have easements that grant the right to use someone else's land for a specified purpose. These can be permanent, meaning they grant ongoing access, or temporary, meaning they grant access for a specified period of time. The acquiring agency must determine if an acquisition will be voluntary or involuntary before starting the acquisition process. If going the voluntary route, the agency can no longer use eminent domain. The URA requirements for voluntary acquisitions and involuntary acquisitions differ significantly. While there are protections for property owners in both circumstances, only involuntary acquisitions trigger the full acquisition requirements of the URA found in subpart B. First, we have voluntary. Under voluntary acquisition, the subrecipient must inform the property owner of the URA rights. They must provide a written acquisition notice and offer letter. Inform the property owner that the subrecipient does not have eminent domain authority or that eminent domain authority will not be used. The owner and owner occupants would not be eligible for relocation assistance, but displaced tenants may be eligible for relocation assistance. Next, we have involuntary acquisition. In this case, the subrecipient must still inform the property owner of their URA rights. Displaced persons are eligible for relocation assistance. The subrecipient will need to follow all steps in subpart B of the Uniform Act, and a comparable replacement dwelling must be made available. Let's move on to the acquisition process. We've broken this presentation down into the acquisition process and relocation process for simplicity, but please note that the two processes will be taking place concurrently. For the acquisition process, we begin with planning, then determine who the owner is. Once the owner is identified, it's important to communicate with the owner early and often. Then we determine the value, the purchase offer, continue working with the owner, negotiate if needed, and finally execute the acquisition instrument. We'll discuss each of these steps in detail next. To plan, we begin with determining necessary acquisitions. Most of you will have easements. Anyone who handles disaster recovery housing projects may have some full title acquisitions. You'll need to estimate cost and staffing needs, employ affirmative marketing strategies. So you'll need to think about how to communicate with the public about the project. You'll hold public hearings, ensure timely formulation and dissemination of communication. So what's the plan for sending notices, who's sending the notices, and at what time will the notices be sent? Then you'll ensure the target audience receives adequate information. So are the administrator, subrecipient, developer, engineer, architect, owners, and or contractors on the same page? And then begin retaining documentation. We have a list of required documentation for the acquisition relocation file at the end of this presentation and available in the documentation checklist available on our website. Next, you'll need to determine the owner. Preliminary title evidence, a boundary survey, and legal description must be obtained from the County Recorder of Deeds office. This is one of the more common issues I see when monitoring acquisition files. To check for acquisition compliance, we do have to know who owned the property to begin with. Next, you'll inform the owner. The preliminary acquisition notice must be hand-delivered with a signed receipt or sent via certified mail and include the statement of the subrecipient's interest to acquire the property. It should request the seller's disclosure of any tenants, include the notice of right of just compensation, include the notice of right to an appraisal and review appraisal and the right to accompany the appraiser during the appraisal. It should include a copy of the HUD brochure when a public agency acquires your property for any full title acquisitions, and then the DED/CDBG easement brochure for any easements. Please also include the name, address, and phone number of the subrecipient's project acquisition contact person. Next, we'll determine the value of the property. For properties to be donated, please obtain either a waiver of just compensation and appraisal rights or a waiver of only right of just compensation if the owner would like to wait to see the value before choosing to donate. The waiver valuation threshold changed from $10,000 to $15,000 last year. For properties valued at $15,000 or less, appraisals are not required if the evaluation is uncomplicated. Some cases where a waiver valuation would not be appropriate might be when the use of eminent domain is anticipated, hazardous waste may be present, or some other factor makes the valuation more complex. For waiver valuations, the subrecipient must obtain a written determination of value based on available data prepared by a qualified person. That qualified person could be a licensed real estate agent, broker, or an independent appraiser. For properties valued at more than $15,000, an appraisal and review appraisal are required. The review appraisal is just a review of the first appraisal, not a full second appraisal. The appraiser must be licensed in Missouri and adhere to the uniform standards of professional appraisal practice. The property owner must be invited to accompany the appraiser during the appraisal as well. There is an exception when determining value. Projects jointly funded with SEMA may adhere to SEMA appraisal regulations, meaning that the review appraisal is only necessary if the offer is appealed. Next, you'll determine the purchase offer. If the appraisal and review appraisal differ, the subrecipient has three options. They can either use the review appraiser's recommended fair market value, or secure an additional appraisal, or have the original appraiser correct their appraisal. You'll also need to establish just compensation. The offer cannot be less than the subrecipient's official determination of market value or the appraised value of the property, and please prepare the statement explaining a basis for the action. Next, you'll continue working with the owner. Provide the written purchase offer of just compensation to the owner via hand delivery or with signed receipt or certified mail. That should include the amount of the offer, the date on which the negotiation for the sale can begin, a reasonable response date by the property owner, which we consider to be around 14 to 30 days, and a summary statement of the basis for the offer. Next, you'll want to explain the acquisition procedures, and then the property owner may either accept the offer, make a counter offer, or negotiate. Let's talk negotiations. Most negotiations are successful. When they're not, it's usually because the owner is willing to grant access to their land, but unwilling to sign paperwork. If negotiations fail, the subrecipient must send the final offer letter. That letter should emphasize the project benefits and cost of delays, reiterate the summary statement of basis for offer, and include a reasonable response deadline, which should be around 14 to 30 days. If negotiations succeed, you can move forward with the acquisition process, making sure that the purchase agreement fully details the terms and conditions. Next, you'll need to promptly record the transfer of ownership, including the deed or easement, at the office of the county recorder of deeds. Temporary easements are not exempt from this requirement. So the subrecipient pays any incidental acquisition fees, such as recording fees, transfer taxes, and title evidence. The subrecipient is not responsible for costs required to perfect a property owner's title, and CDBG will not fund those costs. This chart shows the steps in the acquisition process for each type of acquisition. We sometimes tend to overcomplicate this, but you'll notice that the process for each type is nearly identical, except for the brochure included in the notice and the final recordation process. We'll discuss three types of relocation: permanent and temporary residential relocation and non-residential relocation. Sometimes a project may require persons to be displaced from their dwellings for only a short period of time. Although temporarily displaced persons do not receive the same relocation assistance and payments as persons permanently displaced under the URA, they do have certain rights and protections. Temporary relocation should not extend beyond 1 year. If it does, the tenants must be offered all permanent relocation assistance, which may not be reduced by the amount of any temporary relocation assistance previously provided. The subrecipient must provide reimbursement for all reasonable out-of-pocket expenses, which may include the cost of moving to and from the temporarily occupied housing and any increase in monthly rent or utility costs. And a notice of non-displacement must be provided at least 30 days in advance and disclose the following: the date and approximate duration of the temporary relocation, the address of the dwelling for the temporary period, terms and conditions under which the tenant may lease or occupy a dwelling in the building or complex upon completion of the project, and provisions of reimbursement for all reasonable out-of-pocket expenses incurred in connection with the temporary relocation. When selecting the temporary unit, keep in mind that it must be inspected for decent, safe, and sanitary standards and lead-safe standards. Next, we have permanent residential relocation. This requires relocation advisory services, a 90-day written notice to vacate, comparable replacement housing, moving expense payments, and replacement housing payments. Tenant occupants may be eligible for a rental assistance payment to supplement the cost of leasing a comparable replacement dwelling, or down payment assistance payment to purchase a replacement dwelling. Owner occupants may be eligible for a price differential payment, mortgage interest differential payment, or incidental payments to supplement the cost of purchasing a comparable replacement dwelling. Non-residential relocation covers businesses, farms, and nonprofits. It requires relocation advisory services and a 90-day notice to vacate. Displaced persons may be eligible for relocation assistance, including relocation payments for moving expenses and reestablishment expenses for moving personal property, extending utilities, and professional services to determine a site's suitability. It's very important to contact your assigned compliance specialist if a non-residential relocation is anticipated, as they can get pretty complicated. Next, we'll hop into the relocation process. Again, the relocation process will have some overlap with the acquisition process. We'll plan, provide the general information notice, provide advisory services, provide relocation notices, determine comparable replacement dwellings, provide a replacement housing payment, and provide moving expenses. The Residential Anti-Displacement and Relocation Assistance Plan, or RARAP, is submitted as part of the CDBG project application process. As part of this plan, the community will commit to replace all LMI dwellings that are demolished or converted to a use other than LMI housing as a direct result of the use of CDBG funds. They'll also commit to provide relocation assistance required under Section 104D of the HCDA, and the plan must be adopted by the subrecipient's governing body. We do have a state RARAP. The subrecipient can adopt the state plan or create their own based on these criteria. Additionally, any relocation gets pretty involved, so again, we recommend looping in your compliance specialist early in the process. The General Information Notice is one of the most important notices. It informs of potential displacement and general relocation assistance eligibility. It also informs of relocation advisory services and describes the right to appeal. On that note, the subrecipient should have appeals procedures in place. A sample is provided in the CDBG admin manual. The notice also reminds the occupants to avoid moving prematurely, as that can jeopardize any assistance they may need to. We highly recommend practicing giving advisory services. The majority of the time, displaced persons will not have experience with relocation benefits, so it's important to present the information in a thorough but simple manner. During advisory sessions, you'll determine the needs and preferences of the displaced persons, explain available relocation assistance, explain the person's right to appeal if they are not satisfied with agency decisions, offer and provide transportation to locate replacement housing, offer other applicable assistance such as social services, financial referrals, and housing inspections, provide a current and ongoing listing of comparable dwellings for residential displacements and replacement sites for businesses. We'll need at least 3, and we'll discuss this in detail here in a minute. Supply information on other federal and state programs offering assistance. Provide counseling and other assistance to minimize hardship in adjusting to relocation. Please note that housing counseling provided by a HUD-certified counselor working for a HUD-approved housing counseling agency is required for some of our housing programs, but encouraged for all other projects resulting in relocation. Next, we have a few relocation notices. First, either a notice of non-displacement or a notice of relocation eligibility must be provided. For the notice of non-displacement, this will inform occupants who will remain in or return after completion of their rights under the URA. It also identifies terms and conditions of remaining on the property. For the notice of relocation eligibility, this will, of course, notify of eligibility, describe the date by which the relocation payments may begin, and include the HUD brochure's relocation assistance to displaced homeowner occupants and relocation assistance to tenants displaced from their homes. Last, we have the 90-day notice. This provides the earliest date by which moving is required. It may not be issued unless a comparable replacement dwelling is available and the displaced person is informed of its location and has sufficient time to lease or purchase the property. The 90-day notice must either state a specific date as the earliest date by which an occupant will be required to move, or state that the occupant will receive a further notice at least 30 days in advance, indicating the specific date by which to move. Samples of all of these notices are available in HUD Handbook 1378. At least 3 comparable replacement dwellings must be identified. These must meet local housing codes and occupancy standards, be functionally equivalent to the displacement dwelling. And that term functionally equivalent means that it performs the same function and provides the same utility. While a comparable replacement dwelling doesn't need to possess every feature of the displacement dwelling, the principal features must be present. It must be adequate in size to accommodate the occupants. If the displaced dwelling wasn't adequately sized to begin with, this requirement still applies. The location must not be subject to adverse environmental conditions. It must be currently available and within the financial means of the displaced person. Housing of last resort is required when an owner, occupant, or tenant cannot otherwise be appropriately housed within the monetary limits. This may include assistance exceeding the maximum assistance found at 49 CFR Part 401 for replacement housing payments, or construction of new housing or rehabilitation of existing housing to provide comparable replacement dwelling units, or the displaced household accepting alternative housing assistance such as a housing voucher or project-based rental subsidy. All of these options would require CDBG approval. In some instances, a comparable replacement dwelling may not be available within the monetary limits for owners or tenants. This is where replacement housing payments, or RHPs, come into play. The displaced owner-occupants are eligible for benefits if in residency for 90 days prior to an offer to purchase their home using involuntary acquisition. The offer to purchase date is the delivery date on the initiation of negotiations or just compensation notice. The replacement housing payment is calculated as the lesser of the cost of the comparable or actual replacement unit, plus additional mortgage financing cost, plus reasonable expenses incidental to purchase the replacement dwelling. Relocation payments are not considered income for the purposes of the IRS or the Social Security Administration. Displaced tenants are eligible for installment payments for a 42-month period. Installment payments are required unless the tenant wants to purchase a home. The RHP is calculated as the lesser of the rent and estimated utility cost of the comparable or actual replacement unit, minus the lesser of 30% of the tenant's monthly adjusted gross income, or the monthly rent and estimated average utility cost of the displacement dwelling. The amount of assistance is based on a one-time calculation, so adjustments are not made throughout that 42-month period. Now we'll talk moving expenses. For residential moves, we can only reimburse actual costs. Moving expenses may include transportation of the displaced person and personal property. We would use the state of Missouri mileage rate and cannot go beyond 50 miles. Packing and crating, which includes unpacking and uncrating. Storage of personal property not to exceed 12 months. Disconnecting, dismantling, removing, reassembling, and reinstalling relocated household appliances and other personal property. Insurance for the replacement value of the property in connection with the move and necessary storage. The replacement value of property lost, stolen, or damaged in the process of moving, as long as it's not at the fault of the displaced person's negligence or already covered by insurance. Utility hookups, which can include phone and cable installation. and any application fees or credit reports required to lease a replacement dwelling. Some ineligible moving expenses include refundable deposits, personal injuries, and interest on loans to cover moving expenses. The URA provides two moving options, either the payment for the actual reasonable moving cost and related expenses, or payment for actual reasonable reestablishment expenses, or a fixed payment in lieu of moving and reestablishment cost. Non-residential moves can use either method, but residential moves must only be reimbursed for actual cost. We do have a couple waivers. The waivers listed here apply to 2017 DR and MIT projects. The first is related to one-for-one replacement. This waives one-for-one replacement requirements at Section 104D of the HCDA. It exempts disaster damage units that meet the grantee's definition of not suitable for rehabilitation from the one-for-one replacement requirements. And our definition of not suitable for rehab just means any units for which the cost of rehabilitation, including clear consideration for resolving issues affecting health and safety, exceeds the cap allowed for that project type. The next waiver is related to relocation payments. This one waives the specific relocation assistance requirements at Section 104D of the HCDA. It sets the URA and its implementing regulations as the sole standard for relocation assistance and requires rental assistance to be calculated over 42 months. So what happened with this waiver was that the URA required a 42-month period, but the HCDA required a 60-month period. To assist projects jointly funded by FEMA, HUD did waive that 60-month requirement. There's also a waiver for DR 4451 that allows us to apply these two waivers to our 2019 DR projects as well. These are the items we're looking for to monitor acquisition and relocation. Each acquired property should have its own file with these items included. These lists are also provided in the documentation checklist available on our website. And I'll leave you with a few additional resources. I've linked our acquisition and relocation policy. We've also linked our sample forms. Our sample acquisition forms were updated in January to be more user-friendly and are now available on our website. Also linked the Missouri Licensed Appraiser List, HUD Handbook 1378, which provides much more detail than I'm able to provide in a 30-minute session, and the URA Final Rule, which was released last year.